67 of At Your Service with Haber and Martinez. I'm Haber, and as you can see, Martinez is not here. He may join us shortly. If he does, our producers will pop him in. But whether he does or doesn't, we're honored to have Lawrence Shapiro with us. Lawrence is a civil litigator. He's a friend and a colleague. I've known Lawrence since before I started practicing law. And Lawrence actually gave me my first office. I did not work for him, but he had an empty office in his suites, and I had nowhere to go. And he had pity and compassion on a newly budding attorney. Plus, I was able to serve as his de facto punching bag for a little while, which I'm sure was a lot of fun for him. But I will tell you that even though Larry and I do different types of law, and that's basically what our show is going to be about, I've entitled it Civil versus Criminal Litigation, a Sunshine State Battle Royale. There is a lot of overlap. So there is a lot of overlap between civil and criminal practice in many ways. And just by way of initial example, I remember being taught by Larry how to format a court order. And it wasn't so much as what was in the order as it was how the order had to appear. Again, something they don't teach you in law school. But Lawrence taught me that. And I use the same format today, 31 years later in criminal court, both federal and state, as what Larry taught me back 31 years ago when I knew nothing. So with that little bit of a background, let me introduce Lawrence. He is a practitioner who's been licensed for a couple years longer than me, I believe since 1989. He got his bachelor's degrees from the University of Michigan. He went to Cardozo Law School, and he has an LLM, which is a master's in law from the University of Miami. His practice is Lawrence J. Shapiro and Associates, PA. They have an emphasis on residential, commercial, real estate matters, contract, business law disputes, and some family law matters, although mostly in the area of post-dissolution and collection areas, child support, alimony, palimony, court-ordered support payments that are delinquent and owed. With that said, Lawrence, thank you so much for joining us today. I appreciate your being here. It's good to see you.
Good to see you, Michael. Thanks for having me on your show.
Thank you for agreeing to come on. You know, it is funny when I was thinking about that in terms of, I'm looking back and thinking about those court orders and you know, how they were drafted, the structure, the indentation, the capitals here, the little buzzwords that need to go in there. It's really irrelevant what court you're in front of because the language and the format is all identical.
Right.
But apart from that, I would say there's very little overlap between criminal and civil litigation.
No, they're really two different animals, right?
Yeah, I would say for sure. And we could break it down even further and talk about the differences in civil litigation in state court versus federal court or criminal litigation in state v. federal. But either way, sticking with the kind of civil and criminal, and I'm going to apologize to the audience and to you in advance, because I know that family law has now become its own kind of genre, so to speak. So, you know, they have their own individual family rules of procedure, like we have the civil rules and the criminal rules. For purposes of the show, I'm going to kind of lump family and civil together, if that's okay with you.
Yeah, that's fine. We'll kind of do it that way.
About the differences, the nature between civil and criminal. The folks are pretty much aware. Anybody who watches this show knows an awful lot about what I do and my arena, but maybe not so much about yours. Maybe you can shed a little light on civil litigation overall, your type of practice, what it is you do.
So in the civil arena, right, I kind of wear two different hats. One involves family law matters, and looks like I'm getting a little message. We might be having a little problem with streaming.
Okay, now.
So one involves family law matters, and in that kind of bucket, if you will, I have a law firm. It's called Support Solutions, and Support Solutions is a law firm that is dedicated to the collection of unpaid alimony and child support after the family law case is over. So oftentimes you have a situation where there's an ex-wife, mom, and the husband or former husband was ordered to pay child support, alimony, or maybe both, depending upon the situation. And although the ex was ordered to pay the money, he's refusing or failing to pay. And month after month goes by, and the former wife or the mother of the child or children is basically being starved to death, financially speaking, and could literally be starving to death without resources. So what we do is we typically get involved and we go after the former husband, father of the child, if there are kids involved, to collect that unpaid support. We're very passionate about it. We're pretty skilled at it, and we've gotten good results in the past. Although, past results are no prediction as to future results. Separate from the collection of the child support and alimony, we also offer separately through my what I'll call conventional law firm, Lawrence J. Shapiro and Associates, PA, representation in family law matters. So that could run the gamut from a divorce. It could be a paternity action where the parties were never married, but they have a child or children in common. Or it could be some type of modification proceeding where one parent or the other wants more time or less time with the child, or one parent or the other, or one party or the other wants to try and modify an obligation or change an obligation. Hey, I shouldn't be paying so much child support, or you need to pay even more child support because you're making more money, or my alimony obligation should be changed. I'm not doing as well as I used to, or it should be increased because you're doing far better. So those are, just a big picture overview as to what we do around here as far as family law type matters.
So I want to pick into that a little bit, because you've raised a couple of really interesting points, one of which segues into the next topic, which is billable hours. But I don't really want to get into billable hours yet, because I want to talk a little bit about the distinction between debt collection work and the type of work that supports solutions, very specified debt collection, right? And I want to talk about the idea of contingent fees. And for folks who aren't aware, contingent fees, usually people associate them with personal injury cases. You'll see ads on TV. If we don't get a settlement for you or a judgment for you, we don't get paid, right? That's a contingent fee. If the lawyer doesn't win, it is contingent upon the result in the case. Well, that is an illegal fee in a criminal case. We are not allowed to charge contingency fees. And it's also an illegal fee in a family law case. So if I'm getting divorced and I go to Larry and say, Larry, you're going to take my ex-wife. She's worth millions. I don't want to pay you an hourly rate. I'm going to give you a percentage. He can't do that. Correct?
In the criminal arena, you can't do that. In the family law arena, generally speaking, you can't do that either.
But
there is
one. We're not talking about the family court arena now. We're talking about the post-dissolution election family court arena, which is an exception to that rule, correct?
There is. There is a very limited exception which enables us as lawyers, Support Solutions as a law firm, to try and collect the unpaid alimony, the unpaid child support, or both, after the family law case is over, on a percentage or contingency fee basis.
So for those people who are looking to collect, and I want to not necessarily correct, but amend one thing you said, because you were talking about, basically deadbeat dads, but there's deadbeat moms too, right? So it can go either way. It could be just a parent who's not living up to their financial responsibilities, irrespective of gender. And if the other, in this case, post-dissolution, if one party is not doing what they've been court ordered to do with regards to payments, then the other party could come. Then that party could come to Support Solutions and say, "Hey, Mr. Shapiro, I'm owed $75,000," and you could say, "Well, I'll be happy to go after that, and I'm going to charge you whatever percentage it is." I'm assuming that it's similar to what they do in PI cases, but tell us what it is basically as a general rule.
Right. So that is kind of a good general description as to what happens. Most of the time, although it's not a one size fits all, um, the person that's owed the money, right, is usually the woman. Usually, men have the support obligation, whether it's child support, alimony, or a combination of the two. And when the woman, for example, although it can be the other way around, woman could have a support obligation to the former husband or the father of the child, but where the woman is owed the money, um, and the monies that are outstanding typically do get up there in terms of the amounts. They contact us, and we're able to provide representation on this contingency or percentage basis. And really, that's a godsend, because imagine if you're not getting your basic support from your ex, means you're gonna have a real hard time paying the rent, car payments, groceries, and all the other wonderful expenses of life. You're certainly not going to have money to start throwing at a lawyer who's going to charge you by the hour, not being able to give you any guaranteed result, obviously, not knowing how much time it's going to take or how much money it's going to cost in legal fees. So, excuse me. So, this is really a great thing in terms of breaking down barriers to entry. It allows people that are not getting their support to be able to be represented properly, capably, and without them digging into their pockets, that typically those pockets are empty.
So I would say, I'm curious. I'm actually saying I would say, but I'm asking. I have some familiarity with the personal injury industry, right? And so when you're a PI lawyer and somebody comes to you with a case, whether it's they've been hit by a vehicle or they had a slip and fall or whatever it is, they believe that somebody owes them money for some injury sustained. The PI lawyer will vet that case. They will do their own investigation and then their own calculus to try and figure out whether or not it's worth it for them to accept the case and to invest their own time and possibly their own money on top of their own time in being representing that individual under those facts and circumstances. And one of the biggest issues that those PI lawyers have to consider is whether or not there's collectability. Because you could have the best case in the world, but if you have a client, a defendant that has no money or a respondent that has no assets, then you're basically fighting for a piece of paper, a judgment that's uncollectible, which is rarely worth any lawyer's time. I don't say never, because some lawyers are in it for the glory and the statistics or the principle. But I would assume that support solutions would have to do that same type of a mathematical equation, so that you would need to do some sort of due diligence into the person who owes the money, the debtor, I guess, and figure out whether or not you actable defendant. Would that be accurate or no?
That is accurate. So, in the kind of injury arena, I think a big component of that is, all right, is this a good case? Is the person that's coming to me, a lawyer, someone that's truly hurt? What is this case may be worth? But last but not least, is there insurance? Is there, an insurance company, whether it was a slip and fall or whether it was a car accident or some other type of misfortunate event or unfortunate event, is there insurance that's going to pay or to either settle the claim or pay a judgment? In the family law arena that we've been talking about, and the collection of unpaid alimony and child support, there's no insurance. There's no homeowners insurance policy or any kind of special magic insurance that the court would have ordered the non-paying party to keep so that the support is paid. So yes, a big part of the calculus or the decision as to whether or not to take on a claim is trying to determine, even before we get busy and rolling up our sleeves with court, to see if the person that owes the money is in fact collectible.
And how do you go about doing that? How do you do that math? I mean,
well, if I told you, I'd have to kill you. But it's a good question. So there are several things we do. One, obviously, where we talk with the prospective client and we get information from the client to get a sense as to whether or not the individual is, in fact, collectible. Are they employed? Do they have their own business? Do they have assets? Do they own houses, cars, boats? How are they doing overall? Or, is it a situation where, the ex is not paying any money because the ex is in prison, and that really doesn't bode well for any type of recovery in reality. The other thing we're able to do is, perform some, especially with the internet being what it is, do some investigation into the individual, see what he or she might have, what's in their background, and get a much better sense as to whether or not they have resources to pay.
Now, you've been pretty creative in doing this work. I mean, you and I have shared, you've shared some of your experiences with me off, just shooting the breeze. But for the benefit of the folks, I mean, like, you've been able to find things like safe deposit boxes, secreted bank accounts, correct? I mean, or am I exaggerating and making this up?
We have actually. We've had success, and again, just because there was success in the past is no guarantee as to a future result or any particular case. But yeah, we have had instances. For example, there was a guy. He claimed he was broke, living with his mother, and we were able to determine that it was likely that he still had a bank account, though we didn't know necessarily what was in the account or accounts plural. But we have reason to believe that it was with one of the major national banks. And we went ahead and sent paperwork to the bank to freeze the account. And then the bank, gave us a formal response saying, yeah, there's some accounts. And by the way, there's a safe deposit box, which they have to disclose. We didn't know what was in the box. Nobody really knew what was in the box. I suppose the ex-husband knew what was in the box. So ultimately, we got a special court order. We went down to the bank. The ex showed up, or the ex didn't show up, but hired a lawyer, and the manager escorted the lawyers into the vault. Proceeded to take out the box from its spot in the vault. Opened up the box, and there was a bunch of envelopes. Like if you cash a check, they give you an envelope with dollar bill signs on it, and a bunch of these packages stuffed into the box. Well, they took the envelopes and they brought in a counting machine, a cash counting machine, and they started opening each envelope, and each one of those was filled with $100 bills, and they loaded all these hundreds in and hit the count button and spins the money through the machine, I guess, and out came a figure of some $37,000 odd. So we were able to basically secure. It took some further legal maneuvering, but we were able to get $37,000 paid from that money. That was all the money towards the unpaid support that was owed.
Just out of curiosity, I'm assuming that when this guy was crying poverty and saying he didn't have anything, a lot of that was probably done by way of discoverable pleadings, maybe by way of and I know we haven't gotten into the rules yet, but by way of interrogatories or requests to produce. Is there then a contempt proceeding on top of that if he has made affirmative misrepresentations?
There are things you can do through the system to require people to disclose assets, but my experience is people are not too straight up about things, and it's better to shoot first, ask questions later. So we try and really get our heads around whether there are assets and what types of assets there are and what we can grab without signaling that, we're onto somebody who owes unpaid alimony or child support.
Well, I would say in that last case that you just mentioned, if he had any inkling that you were going to know that he had that safe deposit box, he'd have gone in and cleared it out.
Well, I don't think he ever dreamed that somebody would find out about a safe deposit box, much less that it would have cash in it. And to be able to go in there with a court order and open up that box and then, have the cash basically put into lockdown. So the element of surprise is really essential if you're going to have a higher degree of success in trying to get the money from the deadbeat, if you will.
Is there anything else you wanna talk about with regards to support solutions before I hop on to our next topic? Because I don't wanna cut it short. We can always come back to it later. I think it's a fascinating subject, and actually there is one more thing I want to ask, because I mean I'm assuming that you didn't. This is not something that you started doing as a part of your practice. This is a relatively, I mean, you've been doing it for several years now, but it's a relatively newer component to your business. So, did you get this skill set from your debt collection work that you did as general civil litigation outside of the family law arena? Is that where you got like the baseline for this?
Right. So in enforcing these support obligations or these judgments, it is very similar in some respects to what you would do in a regular civil type case. Hey, I sued my contractor. He never finished the job. He owes me 20 grand to finish the job, and now I have to try and collect. So you have that in these cases, but you also have the fact that it's a family law case, and you have extra arrows, if you will, that you can fire at the other side, at the person that owes money. Because the court system, both here in Florida and virtually every other state, really has a strong interest in seeing to it that child support, and to a lesser extent perhaps alimony, but those obligations are paid. Because when they're not paid, the family unit, has real needs that are not being met, and the state then oftentimes becomes burdened with having to provide benefits to, for example, mom and the kids, because they don't have the money to make ends meet. So the states have a very strong interest and actually are required to, monitor how much money is owed and see what they can do to collect, but they're limited in what they can do. So it was an interesting kind of discovery process where, gee, there's some money owed here, and then the realization that the amount of money owed in Florida, let alone nationwide, is a staggering statistic or figure, staggering amounts. And then learning the tricks, if you will, or the tools of the trade that can be, put to use effectively in collecting these family obligations. So it's been a years-long process, but certainly something that's worthwhile in my experience. And when you get a result for someone, it really changes the lives, not just of the client, but frequently when there are children involved, it really enhances the life of the child. So that's where you're kind of doing God's work.
So the state attorney's office here in Dade County, I'm assuming probably every state attorney's office has a similar platform, but here in Dade County, they actually have a carve out, a division of the state attorney's office called the Support Enforcement Division. And so people who are owed delinquent support can go to the state attorney's office and try and pursue recovery through the state. How does that affect you, or is there any overlap, or is it the same type of thing, or what are the differences?
Right. So we do encounter those situations. So first, the state attorney's office and the division, the child support enforcement division, they're a great, talented bunch of people, the lawyers, the staff. But like anything, it's, still a public kind of service, and their resources are limited, and they have big caseloads, and it's hard. It's not, you don't get the same kind of attention. It's not that they're not well-intentioned. It's not that they're not capable. You just don't get the same kind of attention from that, division, if you will, that you would from, generally speaking, that you would from a private attorney representing your interests. That's number one.
So we could liken that to the situation where we get all the time about the public defender and people complaining about their public defenders and calling them public pretenders, and they're not lawyers. And we always have to straighten them out, because no, they are lawyers. In fact, they're damn good lawyers. It's not easy to get a job as assistant public defender, and it's even more difficult to keep the job. And so I say to these folks, The fact is, they just have very large caseloads. There's only so many hours in a day, and there's only so much they can do, unlike private lawyers who charge big fees or larger fees and are able to keep a much smaller caseload because of the fees that they charge. So I guess it's a similar type of thing with the
It is similar in that vein. So, people have to be understanding. And of course, that's easier said than done when, you're starving to death financially speaking, and you're not getting the support that you're owed, and, you're not able to reach and speak directly with the lawyer, and you don't really know what's going on. So it's difficult.
Does Security Solutions have any involvement in the aspect in terms of dealing with trying to get driver's license suspended or pickup orders issued, KPSs for failure to pay, or you guys are just looking to collect and you're not interested in the collateral stuff?
Are you asking me, does the state attorney's office?
No, if you do, I know the state attorney does.
Oh,
And
yes. So we too can look to do certain things. The way some of the laws are written, it's really not entirely clear as to whether or not those additional things, such as suspending driver's licenses, pickup orders, all those things are only available to the state. We've successfully gone in front of judges, and we're able to make those requests, and at time even have judges order those type of things. When it comes to those arm twisting type of things, those are remedies or things that you can do when you're enforcing a child support obligation. Generally, they're not applicable when you're trying to enforce alimony. Which brings me to another point that people need to know. Yes, the state attorney's office has a division dedicated to collection of unpaid child support. However, they do not, and I want to repeat, they do not collect alimony. They're not allowed to, they're not authorized to. So if somebody is owed alimony, or they're owed a combination of child support and alimony, the only thing the state attorney's office will go after is the unpaid child support. They do not handle the alimony claim.
And alimony, I guess, especially here in a place like Miami, it can be a pretty big deal.
Right, and alimony is, when it is in play, typically that's a larger number than child support. The other thing is, and this is kind of my perspective, the state attorney's office, and again, the people there are wonderful, they're talented, they're capable, but they're kind of like a one-trick pony, right? They do income withholding orders or income deduction orders, suspension of driver's licenses. That's about it. They don't go freezing bank accounts. They don't go busting into safe deposit boxes. They don't repossess vehicles. They just don't do those things because, those are more involved, expensive, and they just don't have the authorization, if you will, to walk down those paths. And those paths can be rather productive. Think about it. If somebody owns an investment property, right, with a lot of equity, they can't rip the building out of the land and run away with it, so you have a sitting target. But if the state attorney's office is not in a position or authorized to go after that property and try and have it sold at auction by a sheriff to raise money to pay off, there's an asset sitting there and no one's going after it. So that's another issue. And last but not least, that people really don't realize is, while yes, the state attorney is in there looking to collect the child support from deadbeats that aren't paying for their kids or kid, they represent the Department of Revenue, the Florida Department of Revenue, not mom. And that's actually in the laws, in the statute. So they're not even representing, the mother that's owed the money, although she will get the money. They represent, and their client is the Florida Department of Revenue. And the reason why that is because Florida, like many other states, provide benefits, and therefore, in theory, the job is to recoup money where the government has paid it out and get it back in to the government. Usually the money goes to mom or for the benefit of the kids, but that's another reason why they're not going after alimony.
That actually dovetails segues nicely into a topic that I wanted to get into, which is a distinction between the civil and criminal practice. In my practice, while my cases vary, I might represent somebody on a DUI in one case and a homicide or a drug trafficking in another, but I always, every time, 100% of the time, I represent the accused. I always represent the defendant. I'm never the petitioner or the plaintiff, because that's always 100% of the time the people of the state of Florida. But civil cases are not like that. Civil cases, I mean, yes, the government can be a plaintiff in a civil case, but general civil litigation between persons or entities, right? They need lawyers on both sides. So when we're talking about Lawrence J. Shapiro and Associates, I'm assuming that you have occasion in some cases to represent the people who are initiating the action, being the plaintiff, or in other cases, people who have had an action initiated against them, being the respondent or the defendant, correct?
Yes, in that regard, you're 100% right. So in the general kind of civil world, lawyers, myself, can represent either side, not simultaneously, right? But it could be representing a party or a business that is suing for whatever the reason might be, trying to recover money or get some kind of court-ordered help. And you can be defending a company or an individual who's being sued and doesn't want to have to pay. They don't feel it's proper, or someone's trying to take some type of court action against them, and you're looking to avoid the court, doing whatever it is that the other side is asking them to do. So we as civil lawyers, we get to represent, if we want, parties that are either plaintiffs or suing or seeking kind of help or relief, and defendants who are trying to avoid, consequences or actions being taken against them.
And in that capacity, you also have occasion to represent both individuals and entities, correct?
Yes. I mean, you have lawsuits involving individuals, you have lawsuits involving entities or businesses, whether it's a corporation, a limited liability company, or something else. And sometimes you have a mix. So again, going back to, say, the auto accident maybe not so much, but a slip and fall, if Mr. Smith is in Publix and he slips and hurts himself, he broke his hip or his leg, he's now suing Publix. It's Mr. Smith individually, but Publix is, a grocery chain. They're a company. So you have a combination of individual and, business wrapped up into one lawsuit.
So in your practice, your Lawrence J. Shapiro and Associates practice, where you do a lot of real estate work and you do a lot of business disputes and things like that, you've represented condominium associations, homeowners associations, different types of entities in that capacity as well, correct?
Yes, I've represented those type of entities. I represent businesses. I represent business owners that are going through call a business divorce with their partner. So yeah, a variety of different companies I've represented in different industries or business areas, and I've represented obviously a lot of different individuals depending upon what their circumstances are.
So what's it like when you're representing an entity, like let's say a condo association? I'm just going to pull that out of the air because most anybody who's ever dealt with a condo association probably knows the rage and frustration that leads to mass murder. Whether you're defending the condo association or going after the condo association, how does that type of dynamic factor in?
Well, a condo association, because you're using that as an example, is a bit unique as opposed to, say, a straightaway business, in that, the condo association is kind of run by the board, the members of the board of directors. So you got half a dozen unit owners, 7 unit owners, 5 unit owners that are on the board. You got a president, a vice president, secretary, treasurer, and they all have their personalities, and it can be quite challenging in dealing with those different people that make up the board, as opposed to, say, a business, maybe a medium-sized or even a larger company that has a very defined chain of command. They're used to dealing with lawsuits to an extent. Um, there aren't really personalities and politics at play to the extent you have in condominiums. Sometimes people have their own agenda in a condominium setting. I'm going to teach my neighbor a lesson. I don't like the way he or she parks her car. I don't like that dog that they have. So that's kind of a unique area, if you will.
The reason I brought it up is I have my own real world example. And it's also a distinction and a parallel between civil and criminal. So in civil court, there are a series of different types of protective injunctions that civilians can try and seek against other civilians, whether it's a domestic violence restraining order, a repeat violence restraining order, a stalking or harassment order, protection against stalking or harassment. These are civil claims. Some of them do have criminal overtones in that they could be the same behavior could be the subject of a criminal case. But I'm not talking about the criminal end. I'm just talking about the civil end, where one person decides to, that they're getting their phone blown up or their email blown up by somebody else just nonstop. It's a pattern of behavior that's just disturbing with no legitimate purpose. And so rather than involving the cops, or maybe the cops just decided they didn't want anything to do with it, or maybe at the same time, they go ahead and seek a independent civil restraining order against that person, and they try and get a court order from the judge directing that person to leave them alone and have no contact with them. So I had one of those where my client was the respondent. The plaintiff was the president of his condo association. He had an outstanding beef with the condo association, and they were not performing to his desired level or standard or satisfaction. And so he went out of his way to drive the board absolutely bonkers as a unit owner, as a condo owner. And so every time he would see the board president, who he had a particular problem with, he would give her a real good what for, including following her in the elevators and sending her texts and emails during the course of the day, and always, being very careful to label them condominium business. But of course, on her end, it was very disturbing, and I could certainly understand, her frustration. And she went and sought the restraining order. And normally, I don't do that kind of work, but for whatever reasons, I had to accept representation in that case. But it was interesting because she sued individually or filed the action individually, but the truth is it wasn't an individual action. It was in her capacity as president of the board. He wasn't harassing her as a private citizen. So it raised all sorts of interesting issues in that particular case.
Well, yeah, I mean, that's a kind of a unique and interesting situation. Is that person acting as the president? Are they acting kind of rogue on their own? It calls into play whether or not insurance would handle some of those issues, whether private lawyers need to be involved, conflicts. So it's, you have those things. It gets a little bizarre, if you will. But, on the more mainstream, with the stay away orders or restraining orders, as they're typically called, or injunctions against domestic violence, which I'm sure you encounter in your line of work. Those are usually more one-on-one, mainstream. You have a couple. There obviously there are issues, and one fears for their safety, well-being, and then seeks the court to enter this stay away order, no contact order, and the other party finds themselves in a real predicament. And that creates problems too if you're at the receiving end of that, because it can affect your ability to get a job, keep a job, own and possess firearms. I mean, those are things you can elaborate on far better than I can, but it's certainly not something you want hanging over your head, I would assume.
But it is also an interesting thing for purposes of our conversation in terms of the overlap and distinction between civil and criminal, right? So the same behavior, let's take a basic everyday occurrence. One person in a relationship smacks the other one. And the one that gets smacked calls the police, or some neighbor hears the dispute and a third party winds up calling the police. And the police show up. Somebody's getting arrested. We know this as a matter of routine. The cops don't show up to a domestic call without taking somebody, if not both people, into custody, because they're not going to take the chance that they leave these people together and walk away, and then somebody winds up either seriously injured or dead, and they have to answer as to why. Anyhow, cops show up, somebody gets arrested. Now, let's say it's a legitimate beef and these people really, have had it with one another. The person who is the complaining witness, that is the victim, is effectively represented by the office of the state attorney for nothing. State attorney is not their lawyer. State attorney represents all the people of the state of Florida, and that victim is a witness in that case. But for all practical purposes, the state attorney is that person's private little lawyer. In the civil arena, if that person now goes to seek a restraining order on top of the criminal prosecution, they don't have to have a lawyer, but they certainly are entitled to representation. And if they decide to hire a lawyer and then pursue a civil restraining order, and the other side, that is the defendant in criminal court, who's now also the respondent in civil court, lawyers up as well, we have two concurrent proceedings going on over the exact same fact scenario. Can we agree on that?
Yeah, you would have two separate proceedings involving the same facts. I think you'd have a little
Same
different.
Facts, same parties, but that's where it ends, because the judges are different, the rules of procedure are different, the rules of discovery are different, the burdens of proof are different. Everything else changes when you separate those arenas. So tell us about the civil end. Let's talk a little bit about what you can do in civil court that you can't do in criminal, in terms of, like, let's say, discovery.
Well, in civil court, look, in criminal court, right, everybody has a Fifth Amendment right against self-incrimination. So I would assume, and you can explain better than I can, that no matter how bad a prosecutor wants to ask questions to the defendant as to whether or not he or she was involved in the crime, what they did, what witnesses they know about, what evidence, whatever it is that they want to ask, they're not going to be able to get that information from the defendant, generally speaking. The defendant has a right not to incriminate himself, generally speaking, I would assume. The civil case, you want to find out if that person, actually violated a contract and didn't live up to their end of the deal. We get to ask them all sorts of questions in a sit-down question and answer session called a deposition. We get to send them a list and say, we want to see all of these documents to really see if you, ordered the right parts, if you really were prepared to carry out this job, if you really had the staff available to finish this job, if you could, if you really were able to do it within 2 or 3 months, whatever the situation may be. So, yeah, you can delve into things in depth in a civil case, where I would assume, you don't get into that level of detail, I would assume, if you're a prosecutor.
So, yeah, and that's where I was kind of thinking, that's where I was going with this. So using the example I had before, where you've got these concurrent situations, right? The defendant is entitled to demand discovery in criminal court from the prosecutor, meaning the prosecutor's got to tender a list of every witness they're aware of who has any knowledge of any facet of this case, as well as any evidence that they have in their care, custody, or control. And that extends just beyond what's just in the prosecutor's file. That includes what law enforcement has. That includes a whole variety of things that are available to the government. That's why we use the term care control, right? Care control or custody. So the prosecutor's got to turn all that over to the defendant. The defendant is obligated to turn over anything in his possession that is going to be used or may be used during the course of the trial. But that's it. the prosecutor cannot compel my client to give a deposition. I can compel any state witness that I want to come give a deposition on to the defendant, but it doesn't work the other way around. It's a one-way street. It's the exact opposite in civil. Both sides get to go at the other basically in an almost unfettered manner.
Right. So, I mean, I think, one would think that the defendant may have the upper hand in the criminal case, but again, you would probably know statistically how those things play out if they go the distance, or maybe given the resources of law enforcement and the prosecutor's office, they kind of get the goods independent of what the defendant is or isn't obligated to give them.
But what we can't do, and what you can do, for example, there's a thing called an interrogatory, right? And that's where you basically draft a statement of fact and you send it to the other side and say, either admit or deny this. Not, don't give me chapter and verse. It's a yes or no, right?
Yeah, there are things, again, paperwork that we're able to send in a civil lawsuit, asking them to admit certain things, or otherwise they have to deny certain things. There are things we can send asking for specific details. How did this happen? Why did this happen? What did you do to prevent this from happening? How much money do you claim you're owed? What's the basis for that? How did you calculate that? So yeah, in civil cases, it's called discovery, and it is what it sounds like. You get to discover or look into all of the facts and circumstances surrounding the lawsuit in a civil case. Whereas criminal, based on what you said, I guess there are limitations that you can further touch upon.
Well, like you said, the biggest one is the Fifth Amendment. The defendant cannot be compelled to make any statements. He cannot be compelled to testify, or she. He or she is free to testify if the client wishes. In fact, it's one of the very few areas in the criminal realm where the client can overrule the lawyer's judgment, right? I can tell my client, I do not think you should testify, and the client can say, thank you, but I don't care what you think. I'm testifying, and then that's it. The decision is made. I cannot prevent the client from testifying. But on the flip side, if it were civil, I could not I could not prevent the client. So in our example, if we have those cross cases, let's say my client, I'm representing somebody in criminal court on a domestic violence case, and there is a concurrent civil domestic violence injunction case, and you're representing the plaintiff in that civil case. You could set my client for a deposition, and he could invoke the Fifth, but his invocation of the Fifth is completely irrelevant in that civil courtroom because it is not a criminal proceeding. And the Fifth Amendment does not apply to civil prosecutions.
Well, yes and no. I think in that instance, first of all, if somebody, and this happens in civil cases, I have one now that it's in play potentially. If somebody is either charged with a crime or has a reasonable fear that they might get charged with a crime. So you don't even have to be charged with a crime. There doesn't have to be an actual investigation, not that you know about it anyway, probably. But if you have a reasonable fear, you can invoke your Fifth Amendment right in a civil case and say, I'm not answering those questions. I'm not showing up to give testimony in a court, in one part of the court proceeding. I'm not going to sit for this deposition when this private lawyer is going to ask me these questions, because I'm afraid that whatever I say can and will be used against me either in a pending criminal case involving similar, the same kind of facts, or I'm afraid that there might be a criminal case and that this is going to be used against me. So you're not necessarily required, but it does come with consequences.
I was just going to say that the distinction I should have said, and I misspoke, because I shouldn't say that you can't invoke the Fifth in civil. You can. But there's a consequence for invoking the Fifth, or at least a potential consequence.
Right. The consequences in the civil case, the decision maker, usually the judge, can basically infer or basically decide that the reason why you didn't say anything and took the Fifth is probably because, it's true. The things being complained about actually occurred. So there's what's called an adverse inference. There's an assumption made that had you have testified, whatever you were going to say would not be in your best interest, would actually be contrary to your interest.
We do have a similar concept in criminal court in one limited capacity that I can think of off the top of my head. And it's similar to an adverse inference. It's called consciousness of guilt. So for example, in a DUI case, you cannot be forced to blow into a breathalyzer machine. However, if you refuse to blow into a breathalyzer machine, then the fact that you refused is admissible. And not only that, but the prosecutor is able to make argument that the reason that you didn't blow is because you knew if you did blow, you'd be providing them with a breath limit, a breath result above the limit. That's called consciousness of guilt. And it's one of the very few exceptions where, and it's the reason is because it's not testimonial. It doesn't fall under the Fifth Amendment because it's not testimony. So they are allowed to make that inference, but that's one of the very limited areas in criminal where they can do that. Otherwise, the judge is absolutely obligated to instruct a jury that you have an absolute right under the Fifth to remain silent. And not only do you have a right to remain silent, but the jury is ordered by the court, absolutely unequivocally instructed that they are not permitted to use the fact that you chose to remain silent against you in any way, shape, or form. And if the prosecutor makes any kind of argument, it's an automatic mistrial if they bring that up. So it's pretty well covered in the criminal arena, but in the civil, it doesn't so much hold true because you do have to deal with that adverse inference. And I've had this happen a lot of times where there are very impatient domestic violence judges that don't want to wait for the criminal case to resolve. Many of them do. In fact, when you have a family law case here in Dade County, anyhow, you have a family law case that's going on, whether it's dissolution, post-dissolution, whatever, up in circuit court. And then those same parties have a domestic violence case that comes in civil, an injunction. It gets melded into the family case as part of the Unified Family Court program, right? So instead of being blind filed to a acting circuit court judge who handles strictly DV cases, that particular DV case will go to the judge who's assigned to the circuit court case. So you tend to have more experienced judges, not always, but sometimes. And so usually in my experience, those circuit court judges will defer and kick the case down the road and allow the defendant to resolve their criminal court matters without pushing the civil. But every now and then you come across a judge that's got no patience for one reason or another. Maybe it's just a bad day, or maybe it's their protocol and practice. But you have some judges who say, too bad, so sad. I'm not clogging up the arteries of my audit because you have a Fifth Amendment privilege.
Right. So, you do have that in family law. There's the interplay. I think a lot of that is because, more often than not, their kids are involved, and the issues involving the allegations of domestic violence are going to, be a factor in deciding time sharing and, visitation and things of that nature, and what's in the best interest of children. So I think that's why they kind of loop or link those two together. In the general civil world, look, if you have a situation where a client either is the subject of a pending criminal charge or may be, and yet they're going to have to deal with answering questions or turning over records or documents in a civil case that really would hurt their ability to defend themselves in a pending criminal matter or a potential criminal matter, the courts can put the civil case on hold, basically, until the criminal case is resolved one way or the other through a trial, I guess some kind of plea, and then resume the civil case. So, it can present some challenges, but that's how, I guess, those two separate worlds function.
So I want to hit one more topic, and this is kind of an intersection topic for us, because there have been a couple instances over the years where you and I have collaborated on cases. There's one that I can remember not too long ago where I had a client who was a criminal defendant, and he was sued civilly by the person who had accused him and who was the victim in the criminal case, and you came on to represent that individual in civil court. And again, because the rules in civil court were so much more available with regards to the discovery on our end, you were able to do an awful lot of work that inured to the benefit of my client in the criminal case in terms of the civil discovery that you did in the civil case that I could never have done in the criminal case. Right?
Right. Yes, you can use the civil. Yes, and I know what you're talking about without
Right.
getting into names. You can use a civil case maybe to help bolster your defense in a criminal case by getting information, but you also got to be careful because if you start asking for a lot of stuff and you're a defendant in a civil case, but then you don't want to answer questions or give information because of the criminal case, there are some judges that wouldn't take too kindly to that kind of double standard. I want to get information, but I don't want to give information. And the judge might say, you're not getting info because you're not going to be giving info. In fact, we're going to put this whole thing on hold. But that's again, not a one size fits all. It could be effective. You could use the civil case as a way to kind of get information to help bolster your criminal defense.
Well, and in that particular case, not only did it help us in terms of bolstering the defense, but it wound up helping us to resolve the criminal matter favorably, even though that particular client had to go more out of pocket on the civil end. But I mean, I guess in a way you could say he in part bought his way out of the criminal case. But to him, the criminal case was far more damning than the civil. The money wasn't as big of an issue to that particular client. So we were able to work together to leverage the civil to the benefit of the criminal.
Yeah, I mean, we've done that together, obviously, and yes, money doesn't buy happiness, but it might buy some freedom.
Well, in certain cases, right? There are some cases that lend themselves to that. And also we've had the opposite occur where we've had a criminal charge brought where we wound up filing a civil case against the complaining witness in the criminal case and made that person a defendant on the civil end, now having to go out of pocket to hire a lawyer to defend themselves where they were being represented by nothing and laughing all the way while the prosecutor was, stepping on my client. So it kind of flipped the tables a little bit and gave us, another sort of tactical advantage where that person had to think about, what is this really worth to me? And again, these are all very case specific situations because it's not using one to the detriment of the other across the board. It won't always work for you, but there are circumstances where it might.
Right. Yep. You can sometimes there is a certain dynamic that can work in a party's favor, when they're.
Well, we've definitely done our share of collaborative efforts. And, even though we don't practice in the same arena, again, I want to go back to something I said, when we first started the show. Many of the things that I learned from you, just as practical, this is the way things are done, have carried over almost 32 years later, that I still do the same thing. I still draft my pleadings the same way. I still use the same type of, layout on my pleadings. And that's stuff that I learned from you on the civil end that really is irrelevant to the criminal, except that it really is the same. Lawyers speak a certain language, no matter which practice area you're in, and judges and appellate courts speak a certain language. And so we all have to be familiar with those terms and protocols in order to be able to move forward and do things. Obviously, it's a little different today. We're not using an IBM Selectric. Everything's done electronically now, but it was different. It was done by hand, and that's how we started. And I'm very grateful for that. I'm also grateful for, our 32 years of friendship and collaborative efforts, as well as for you taking a billable hour out of your day-to-day to
Right on. Well, Michael, it was a pleasure. I want to thank you for having me on the show. There is a lot of differences in the civil arena versus the criminal arena. Family law is different than criminal. Family law is different than civil. You don't have a jury deciding the outcome, say in a family law case. You only have a judge, at least in Florida, So there are differences, but it's good to know that your followers have someone they can call upon in the event or in the hopefully non-event that they find themselves in need of your services. We're certainly happy to be of assistance if anyone finds themselves caught up in a civil lawsuit or they have a situation where they're not getting their support, whether it's alimony or child support. We're happy to assist there. And if they have a different type of family law issue, we can also represent their interests.
So just so the folks are aware, and again, there's a ticker running across the bottom of the screen, but in terms of the support services that Lawrence provides, support solutions, check out OWED Support. That's OWED support.com, 1-844-PAY, P-A-Y kids, or 1-844-PAY wife. And Lawrence or somebody from his team will be happy to assist you with your problems. And if you have any general civil litigation issues, also you can reach Lawrence through his law firm at 305-379-3111. Thank you again so much for joining me today. I really do appreciate it.
Thank you, Michael.
It's been a really interesting and informative show. And hopefully you'll come back and join us for another episode. I'm sorry Martinez wasn't here today. I know he'd have had a lot to say because he always has a lot to say.
He does.
He also does some civil work and some family law work too. So I'm sure he would have appreciated being able to chime in on that. But another story for another day.
Very good.
Or we can talk about another time.
Thanks again, Michael.
Thank you very much. And thank you to the folks at Miami's Community News for producing the show today. As always, they'll be sending out links that we will upload to our various social media. So you'll be able to see this not only on Facebook, but on Twitter, Instagram, MeWe, YouTube, and pretty much anywhere that you get your news from or social media from. Next week, we have another guest joining us. I'll give you a little bit of a teaser. It is going to be a show on the medicinal marijuana industry and the laws and regulations surrounding medical marijuana, recreational marijuana, decriminalized marijuana, and states and the federal government where marijuana is still completely criminalized. That said, thank you very much for joining us today for episode number 67 of At Your Service with Haber and Martinez. Thank you again, Lawrence. We'll look forward to seeing you guys next week for episode number 68. Meantime, have a great week, everybody, and thank you.